This is Paul. Yes. Just looking at that Equal Protection Clause, Amendment number 14. Nor shall any state deny to any person within its jurisdiction the equal protections of the law. Statutes that discriminate arbitrarily must be subject to strict scrutiny, supported by a compelling government interest. And then statutes that have a rational basis for discrimination must be supported by a legitimate government interest. Now, this government of the state of Washington that has an interest in obligating people to go to well, obviously I'm being discriminated against arbitrarily. I never got notice of court hearings. Pooch. Every declaration, every statement was fraudulent. You used a forgery of somebody elected to office. It's obviously that you're discriminating arbitrarily against me because you won't remove me from the docket. Now, this compelling government interest, pooch, strict scrutiny. No one in the state of Washington feels an obligation to make sure that restoration laws are not overbroad, pooch, that there doesn't have to be some sort of speedy trial or a waiving of speedy trial after the evidence and a hearing proving somebody is, well, actually guilty of the crime. Ouch! Now, I'm gonna have to challenge this whole government interest in admitting individuals to mental institutions for the allegation of civil contempt of restraint provisions. Yes. Now I know you have to get me, don't you? Now when I get to suing the state governments for arbitrarily, what do they call it? Arbitrarily using the restoration laws to admit individuals into mental institutions. Pooh. Now, you can't be arbitrary. Yes, you just can't. And this whole concept of the statutes have a rational basis for discrimination must be supported by a legitimate government interest. Now, is it in the government's interest, the federal government and the state's governments, to admit to mental facilities and administer psychotropic medication to those that they have not proven as being guilty of any crime? Ouch! No. Now, I know you're a government employee. Pooch, you're sitting there at home doing nothing today. It's Saturday. I'm sitting here outside waiting for the library to open so I can put this on YouTube. Yes, one of the channels that you don't know which one of them I'm going to do it because I can't title the videos. I don't want to violate those YouTube community guidelines, but I do want the government to realize that is it in the compelling government interest, yes, the legitimate government interest of the United States of America to have people going to court without any due process at all? Now, when I get to suing today, because it could be one of those multi-billions, considering substantive, ouch! I know, it was so much easier saying I was crazy. Now the key takeaways. The Bill of Rights is the first 10 amendments to the Constitution and contains many protections for criminal defendants. Yes, those that are accused of crimes are called defendants. They're defending themselves against the accusation of crime. Yes, it is. Then there's the selective incorporation applies most of the constitutional protections in the Bill of Rights to the states. Then there's a substantive due process, protects a criminal defensive from unreasonable government intrusion. Is it unreasonable for the government to intrude on my life because the deputy prosecuting attorney decided to file a 2-count criminal complaint and nobody from the police department asked me if I was in Brennan, Washington? It's not government intrusion for prosecuting attorneys to use their prosecutorial discretion to obstruct somebody's personal life and then obligate them to a mental health evaluation and admitting them into a mental fucking